Thank you.
I'll do my questions, and Senator Johnson will do his. We expect Rick Scott of Florida to come at a later date to ask questions as well. The three of you made protected disclosures regarding DHS and Border Patrol failures to obtain DNA from illegal immigrants at the southern border as required by the law. And based on your opening statements, the Biden-Harris administration has failed to comply with the DNA Fingerprint Act. Mr. Jones, I'd like to start with a threshold question. How do DNA profiles help DHS, CBP, and other law enforcement agencies protect our communities and at the same time secure our border?
Senator Johnson, the DNA profiles that are generated by the collection at the border allows law enforcement to then log those DNA profiles in the CODIS database. If there is a latent or a crime scene DNA sample that is in that database, then it gives law enforcement an actual lead or investigative track to be able to reopen or open a cold case. The majority of the cases in that database, 45 to 50%, are sexual assault and rape, followed closely by homicide. In our experience since 2020, we have seen very interesting and promising results that come from these DNA profiles being loaded. The oldest case that was reopened, sir, was from 1972, which was actually a sexual assault. So the value to law enforcement is immeasurable. It's in addition to fingerprints and photographs, and it gives our state, local, and tribal authorities the ability to follow up on cases. It gives victims and their families a level of closure, and it can also exonerate those that have been possibly wrongly accused.
If the Biden-Harris administration followed the law instead of flouting it, how would that have played a role in preventing the murder of Rachel Morin? For you, Mr. Jones.
Sir, as we look at the failures and successes, even at the 37% threshold that we're seeing today, in focusing on the case you referenced, we know that the subject was encountered by CBP and DHS at least 3 times. His DNA was never collected. On his 4th trip across the border, he's said to be a gotaway. He avoided DHS and CBP, Border Patrol, and was able to get into the United States. He ended up in California, and in March of last year, he was involved, according to law enforcement, in a home invasion and sexual assault of a mother and her 9-year-old child. In that encounter, law enforcement was able to collect DNA samples and sent them to CODIS. Unfortunately, there was no match because we did not collect his DNA as we should have. From March and until August, there was no investigative lead that would have led us to the subject. Do we know if we had that investigative lead and had identified the subject, we could have located him? Possibly. We know that there would have been an NCIC record placed into the federal law enforcement system that said if any state, local, or federal agency encountered this subject, he would have popped as a person of interest in the original home invasion and sexual assault of a mother and a child. He could have been apprehended. We could have had a person to look for. Do we know if we could have absolutely prevented Rachel Morin's rape and murder? We don't know that, sir, but we do know that if we were able to identify this subject earlier, he would have been on law enforcement's radar and potentially apprehended.
Also for you, the administration's DHS and CBP aren't collecting DNA at some locations at the southern border. Where, why, and what's the impact on our national security?
Sir, Senator, a colleague of ours was visiting sites along the southern border. And they went to approximately 12 sites, and neither Border Patrol nor Office of Field Operations were collecting DNA at any of those sites while they were present. They asked the officer and agents why they weren't doing it, and the response our person told us was, they're just not doing it. The impact is, again, we are allowing investigative leads to get past us, and we're frankly violating the very law that was passed by Congress in 2006 and implemented by the Department of Justice law enforcement entities in 2009. So the impact is clear.
Mr. Taylor, regarding the ongoing whistleblower court case with your colleagues, has the administration, DHS and CBP, made false or misleading statements internally or explained or public about it? If so, please explain.
Yes, Senator Grassley. When the Office of Special Counsel began investigating our allegations of whistleblower reprisal, this started back in 2018, CBP told the Office of Special Counsel that we were poor performers and were about to be fired. When the OSC pointed out that we'd received significant awards and public recognition for our outstanding work 6 weeks before the dismantling of our group, CBP then stated that we weren't a good fit in our current organizational location. When the OSC told CBP that we were reprised against and should be restored to our previous position, CBP told the OSC that the funding was no longer available. When the OSC pointed out that CBP's recently submitted budget included expanding the number of personnel in our WMD division by 500% over the next 5 years, CBP said that that money was reappropriated. A seemingly innocuous email sent by me to CBP's Finance Center confirmed that the WMD funding was indeed available and currently being utilized elsewhere by CBP, as it is today. In fact, one of our salaries, as Mr. Jones had articulated earlier, has been paid out of the WMD budget for the last six plus years, proving our point that the Office of Special Counsel has been perpetually lied to by CBP. Numerous individuals in multiple offices in CBP have made known false statements to the OSC, the Merit Systems Protection Board. They've also made known false statements to congressional oversight groups. CBP's table of offenses clearly articulates that the penalty for knowingly making a false statement in an official inquiry is removal. There are no mitigating factors, and yet no one has been disciplined. On September 23rd, Senators, you are aware, you wrote to Secretary Mayorkas and Acting Commissioner Troy Miller about CBP making false statements to the press. Your staff had confirmed with the Office of Special Counsel twice that the Office of Special Counsel had sought corrective action on our behalf. CBP made public statements to the New York Post stating, quote, the Office of Special Counsel terminated its investigation into these claims without issuing a prohibited personnel practice report or seeking corrective action. That is clearly a lie. Rather than issue a retraction, CBP stated that, quote, this is a mischaracterization of this issue based on incomplete records, and we are unable to comment further based on open litigation regarding these cases. Lie, deflect, and lie some more has been a winning strategy for CBP since 2018. They are lawless and proving to be accountable to no one. As we've mentioned to the various oversight groups we've spoken to, Senator, CBP is the equivalent of a multi-billion-dollar corporation. They have their own press corps, and they can make statements to the press regardless of how dishonest or untruthful they are. And they're given the benefit of the doubt that the average citizen would not believe that an agency would openly make a public statement that was so patently untrue. As you are aware, and your staff called CBP out on this factual and known misstatement, they continue to do so and operate in all these facets with impunity.
Okay, I'll stop and let you, you go ahead. Are you done, sir?
Yes, Senator. Thank you.
Okay, go ahead.